All right, good afternoon, everyone. We've got about a minute until, well, right, 1 o'clock on the dot. So we're gonna start seeing some folks trickle in into this webinar platform, and then we'll go ahead and get started. Give it a couple seconds here. All right, well, good afternoon. I'm Julia Gordon. I'm the State Director of Government Affairs for the Washington Hospitality Association. And we have with us today Catharine Morisset, who is an HR employment law attorney specializing in the hospitality industry, who is here to answer a lot of the burning questions that have been happening as we slowly phase into reopening. Just a couple of housekeeping questions, everyone, or comments. Everyone on here is muted. There's a chat box that you should feel free to put any questions on in there. We'll be pausing periodically through this presentation to get questions answered. And if for some reason there are more questions than we can answer, we will work to get those addressed and sent out at a later time. So with that, Catharine, I'm gonna hand it on over to you.
Great. Happy afternoon, everybody. Thanks for joining me from my home office to talk about what we need to be worrying about regarding our employees as we get ready to reopen. As Julia said, please do send questions, because if we have too many, we'll go ahead and just answer them after. I try to take a look from time to time as we go through the presentation to see if I can catch things. I'll either do that or I'll catch your question at the end, but please be assured that we will go back to you. We have a lot of information to go over today, so I'm going to do my best. Julie and I had a chance to speak ahead of time and identify some things that we think where you've got some FAQs, so I'm going to hit them. This is a presentation form. Hopefully I will get to what I see as the hot topics that I've been hearing from my clients most recently, and that what we, everybody here at the association has been dealing with as well. So my first couple slides are just your general guideline for what you need to be thinking about as you're getting to reopening. And surprise, surprise, the first thing I'm going to tell you is that you should have a plan. And this plan needs to probably be more than just thinking about it. It's going to need some writings from you, some employee communications from you, and some thoughtful questions about policies. I've put here regarding some specific things that you all here need to do, which is decide about temperatures, have a plan for symptom checks and masks. Everybody is asking me about waivers, so we'll talk about that too. And then there's some lawful pitfalls I want to be sure we highlight. Discrimination, we're going to have some tax guidelines we need to deal with. We're going to have employees who are reluctant to come back to work for a number of reasons. And then the next biggest set of pitfalls I see are having to do with all of these leaves. Washington was difficult enough to figure out what employees' leave rights were, and now we've got a couple of federal ones thrown in as well. So I'm going to go over those and give you some resources where you can look things up. And then there's some pitfalls that I see folks falling into, having to do with wage hour mistakes. That's overtime, meal and rest breaks, and how you pay your folks. And the last thing on this slide, please indulge me. I am an employment lawyer, and this is what I focus on. However, this has been one of the most challenging legal landscapes that I've had in 20 years because I have law changing every day, regulatory guidance nearly changing every day. We've got, I'm sure you all are feeling this, healthcare advice changing every day. And sometimes we're sitting waiting anxiously to hear what's going to happen next, like I'm sure we all are in some of the counties where we're waiting to hear from the governor. So if you need legal advice, I really recommend and suggest, in fact, I'm telling you to consult with an attorney. because it's so easy to miss something. And I don't want any of you to be focused on the legal compliance issue. I want you to be able to focus about coming back to business. These are 4 key sets of resources that you can go to help you out with your reopening plan. I feel like the association, and in my firm too, I'm on the COVID task force. We've done such a great job putting together information for everybody that can almost be overwhelming on how to find stuff. The association and I can certainly help you before you get lost in a sea of FAQs, but these are really your 4 main landing pages. You'll be able to click through the links when we send out sets of this slides to everybody. But the association's put together a great reopening guide. My firm has things including an FAQ on pandemics, to some free forms and a whole host of other things I'll talk about more in the end. Any of our questions regarding health-related issues, we all should be taking guidance from the CDC, and I've given you the landing page here to the restaurant and bars tool. I actually looked at this yesterday and liked it. It's a one-pager for what you should be thinking through before you decide to reopen, and I like that they managed to gel it down to 1 page. And then, of course, we have, so far at least, our governor handling the specific industry guidelines. And we have them here for restaurants and bars, and that's the link. Of course, we may be moving to a more county by county plan. So in the future, you probably are going to need to be checking with your county website and local health department. But for now, particularly for phase 2, it's governor guidelines, and here's the link. Here is my list of things you need to be thinking about as you look through all of their sources. You've either got to have a team or one person who is in charge of handling the response to COVID. Maybe you're a small business and it's going to be you, the owner. I would suggest that you bring in your general manager to help you out. Even if you're part of a multi-property hotel, I think that you need to have somebody at the higher level who's handling this and somebody who's the designated go-to on site. Somebody's got to have the task of keeping up with all of this information, and it can be daunting, so dividing it up is going to be helpful. One of the things that we've got to have now for going into phase 2 is a written worksite specific COVID plan. And the reason I say we have to have that, well, we have to have our safety protocols in writing, and we should be communicating those to the employees. There's also rules I'm sure you've already all looked at about how often you need to clean, things like that. And having it all written in one place is going to be what you want to do. Don't forget about OSHA, or I said WSHA, Washington State Department of Safety and Health, handles all of those things in first blush rather than OSHA, but they work together. And sometimes I find that the OSHA printed guideline comes out more quickly and is a little bit helpful. And my last thing here is, you're going to get employee questions from ones that make sense to ones that don't. If they're really strange, reach out to me, because I like to collect them and see if I can help you out. But even if you don't have HR support, I think you want to have somebody who's the go-to, because that person is going to start to come up to speed on lots of different pieces of knowledge in terms of facing the employees. And we also want to be sure employees are getting consistent information. So it's really better to not try to make all of your managers grasp all of this information. It's okay to have somebody who needs to be the key person to answer questions. All right, the biggest thing here that we need to be thinking about before we reopen is how you're going to handle pre-shift screening. You do need to have a protocol in writing, and that's for several reasons. One of the things I just shared with you is because we're going to want to give it to employees and have them sign off on it. There's other reasons that's important, and we'll talk about that later. The next thing is writing it down means that you have a plan and you've thought about the ins and outs of it. So here's the basic requirements for what you need to do. Our state is not requiring temperature checks for your industry. Those are still optional. If you want to have a temperature check plan, I have some materials I could send you on some considerations you need to think about, but it is optional. You can also even ask employees to self-screen at home. And in fact, some industries are being encouraged to do that, including yours. So maybe you have a checklist that includes taking a temperature. Although I don't know about you, I can't get a thermometer right now. So I'm probably not going to be able to report if I've got over 100.4 degrees, but it's something to think about. The next thing you need to be ready to do is check employee symptoms. And again, that should be a list based on symptoms that the CDC has come out with saying could be potential indicators of COVID-19. If any of you were paying attention, it started off with just being difficulty breathing and fever. Now there's other symptoms such as losing sense of smell and achiness and fatigue and some other things. So you're going to want to have a checklist that follows those symptoms. The next thing we want to do is not only communicate to employees what our policy is, but we want them to sign an authorization or really an acknowledgement that you're doing this. And that does a couple things. It helps us ensure that we have the employee's permission, although really you're required to do this by the government, so you really don't need the employee's permission right now. The next thing is I like employees to know what's going to happen and have clear communication, and I think this can be a helpful piece for that. The next thing is you need to designate somebody who's going to do the symptom checking or temperatures if that's something that you want to include. And that person needs to be trained on how to conduct them. Now, the training isn't formal training where they go for hours, but there's some CDC and OSHA guidelines that we want to communicate. The first thing is that employees need, whoever's doing the symptom checks need to understand that this is confidential medical information. So you're not going to line up everybody who's coming on for their time in the kitchen and ask them all as a group whether they're exhibiting any symptoms. That would violate health privacy rules. It's not HIPAA, it's actually the Americans with Disabilities Act, but just remember health privacy rules. You can't do that. It's got to be a one-on-one discussion and check. And the other reason that we want to train that person is we don't have our designated symptom checker be somebody who has no protective equipment. That person should at least be given a gown and a mask. Maybe we even have a face shield for that person and some gloves. We need to be sure that person feels safe, and we want to also be sure that we're meeting with CDC guidelines for that. And then the next thing that we're recommending is that you have I said temperature / symptom check log. The reason for that is you might still be doing temperatures, but if you're just doing symptom checks, you should have a log. But the log shouldn't be what I actually said. Let's say you're screening me. It's going to be a yes or no. Catherine, do you have a fever? No. Does Catherine have a cough? No. Can Catherine smell it? Has Catherine having any problems smelling or problems breathing? No, no, no. In fact, it may just be a log where you log in that you talked to the person that day and that they passed the test. But it should have the questions that you're going to ask every day attached. Those questions should be what the CDC and our state health department says you can ask. You can't add other questions to it because we're probably going to run afoul for some sort of law. And the reason that I'm recommending you keep this is because right now, at least the governor has said that this is something that you have to do. So I want to be able to prove that you did it. You're also going to probably want it in case you ever get into a workers' compensation situation, which we'll be talking about in a second.
Hey, Catherine, before we move on, I know that you're going to get into further questions about employees who say that they're sick or want to use leave, et cetera. So we've got a couple questions that have popped up. I'll wait until you get to those slides. But in terms of the employee screening, if an employer wants to take temperatures, so they're exercising, I guess, their optional right to do that before employees start, if they have an employee who refuses to provide their temperature or allow that to happen, what rights does the employer have, or what should the employer do in that scenario?
Yeah, so right now, all of the guidance that we have tells us that the employee who refuses to have their temperature taken doesn't have a claim. So because temperature taking is recognized as something that is reasonable as a preventative measure right now, we also have guidelines from the EEOC telling us that we don't need to worry right now about it being an unlawful disability-related inquiry. There is a direct threat exception under the ADA, which is basically if you feel you need to take temperatures and it's something that you're choosing to do, then that. So the answer is the employer has the right to enforce its policies. I want your safety policies to be reasonable and be based on, CDC or local State Department guidelines. I don't want to be based on something that you made up. And generally, I'm going to give you the lawyer's answer. Sorry, Julia. Before you fired somebody, I want you to connect with an attorney because there might be something else going on here other than the temperature refusal. But generally, you have the right to enforce that. I also just see a question popped up about, can the checklist or questionnaire be something that the employee answers on their own and turn in? Thanks, Jennifer, for the question. The answer to that, from my point of view right now, is no. The governor is saying that you need to take employees' temperatures and take employees' symptoms check, and has put it on the list for employers in the restaurant industry to handle. And so because we don't have a guidance that allows for self-checks, in fact, it is going to be something that you, the employer, need to go through every day. I also don't want you collecting longer checklists that people have filled out. What's better is that you have a log that shows that somebody went through all those questions with the employee and that they, in essence, passed. That's what you're going to keep. I don't want the longer medical information because that's going to get you into trouble and basically create more paperwork that you now have to hang on to. In fact, one of the things that practically getting this done may mean that you need to stagger start times for folks because this time is compensable. Angie also asked a question about self-check, and no, really, somebody who's designated needs to do this and maintain the log right now. I do encourage, though, self-check at home because hopefully employees would prevent themselves from coming to work at all. And so that in that sense, the check that you're going to do on site is going to be that much faster because employees had a chance to look at home. So a common question that's come up is, should I or can I have employees sign waivers about coming back to work? And by a waiver, the question I'm getting is, can I have employees sign something that says they promise not to sue us if they get COVID now that we're reopened? And the answer to that is very simple. It's no. And the reason is that workers' compensation is designed to provide an alternative for employees to bring an injury-related claim against an employer of lieu of a direct lawsuit. So that's a long way of saying workers' compensation claims can't be waived. Now, this is one of the reasons, though, that I'm having you communicate your protocols to the employees. It's another reason I'm having you maintain the symptom check log. And it's another reason that we're going to have employees sign off and affirm that they're going to follow your safety protocols. One of the other reasons with that is because there is a single exception that matters here for workers' compensation claims. And that's when an injury is inflicted with deliberate intention. It's in quotes because that's what the statute says. And what that means is an employee brings a claim and says, you, employer, knew what the safety protocols were that the state of Washington or the King County or the CDC put into place or OSHA put into place, and you chose not to follow them and I got sick. That very well could be an exception to workers' compensation, and you could find yourselves into trouble. I think it's narrow, and I think you're going to have a good defense if you've got all of your safety policies and procedures in place and you're following current guidelines. And so yet this is another reason why acknowledgement of your safety protocols and that you're following what our governor or your county has stated that you need to do. The next common question I'm getting is something that I can't fully answer here in our presentation because it's a little bit more complex of an answer, but I wanted to give you a rule of thumb. If the sad news occurs that an employee is diagnosed or has been exposed to COVID-19, I've had, employees of clients where their spouse or significant other gets it, or perhaps unfortunately, somebody comes down with it at work, and now we need to worry about to whom they may have been exposed. We've come up with this number that I'll probably never remember, but it's 61548. And the link here takes you to a longer article about it. But basically, this is the rule. You need to identify any employees who worked within 6 feet of the infected person for more than 15 minutes and within 48 hours prior to that individual showing symptoms. So if I call in and tell you on Wednesday evening that I have shaking and chills and a fever and I'm having difficulty breathing, that means you're going to have to go back to Monday. There is no current duty that you report any illness of your employees to the health department. The medical provider takes care of that. Of course, some folks are going to self-quarantine. It may not at present end up with the healthcare provider, but for now, just know that's not something on your deck. And if this happens, it's really worth reaching out to get some other guidance. The CDC has expanded and updated its FAQs for businesses regarding diagnosis or exposure. It used to just be one landing page on this question. Now it has a bunch of FAQs. And this when should an employee suspected or confirmed COVID return to work has become a longer and different answer as time has gone on. This is where it will walk you through how long the employee needs to remain in self-quarantine. One of the criteria, for example, is the employee must have had no fever for at least 72 hours without taking any aspirin. And there's some other things there. This is really one where if you face this problem, you absolutely need some legal help or some help from an HR professional to walk you through it. We want to protect everybody and we want to protect the general public, and that's what this is designed to do. Okay, even though
just going back, if you have an exposure or an employee who has tested positive for COVID, do employers have an obligation to notify the rest of their employees? And then how would they do that while maintaining confidential medical information?
Yeah, so you do have an obligation to notify everybody in our 61548 bubble. And the guidance to employers is that you should not share the employee's name. Now, you and I, Julia, and everybody else on this call knows that when our business is small and you're only talking to the kitchen staff, it's probably going to be pretty clear who might have gotten sick. And the guidance we've gotten from the various federal agencies is we know that, but you're going to do your best. So when you're calling somebody who falls within the 615 or 48, you're not going to say, Catherine has COVID and you were working with her 2 days ago. You're going to say somebody has unfortunately contracted the disease or is suspected of having it, and we need to take some measures now to protect our employees. And you're one of the folks that we're concerned about. So look, I know that you're threading a little bit of a needle, but the sensitivity rule is that you are not supposed to share employees' names with even other employees. And if you get one of these employees who's in the 61548 bubble who says, I have a right to know who's sick, the answer is no, they do not. They have the right to know that there may have been an exposure and that you're taking steps for it, but they don't have the right to know that person's name. And so you want to be very careful that really only those with the need to know about it. Now, about that person's name. You also asked Julia, what do you do for the rest of the restaurant, for example, if it's just a restaurant? The answer is that you may want to go ahead and just let everybody know that there was an exposure. You're going to need to decide what's best for employee morale and what's best to be concerned about a rumor mill. So I can't really advise you in terms of that for this webinar, but there's some things to think about there. But the only people you have to tell is this group. And somebody asked me if it's 15 minutes consecutive or cumulative. It should be cumulative. You want to interpret these more in favor of letting somebody know than not. Did I get your question there, Julia?
Yes. And then I saw one more pop up that are those employees who have been exposed, are they required to quarantine?
Yeah, the answer is going to be, if you click through the CDC guideline, that you're going to want to send them home until they're symptom free. And that guidance that I gave you to is going to tell you the difference in amounts of time if somebody's being tested versus somebody is being tested. So if you send them to get tested, then there's a different set of rules than if somebody's not going to actually be able to go to the doctor and get a confirming or not confirming test. But you do immediately need to arrange for those folks to not come to the workplace, and they're going to have some leave rights, which we are getting to, I promise. Okay, I quickly want to talk about customers. This is getting outside of my purview and practice area fairly quickly, but as it relates to employees, I can tell you a couple of things. You want to be thinking about communicating with customers something at a minimum, even if the state wasn't requiring it, because your employees are going to want you to do that. There are required signs. The association has put together a ready to serve series of signs to be posted that I like quite a bit. You should think about updating your website with current safety protocols and what you're expecting of customers. For example, I have some clients who are salons, and we had to do quite a bit because there's actually requirements for the customers before they can come in. And then look, you could have this other class of people who aren't necessarily your guests, but they're going to be vendors. You could have some different rules for if somebody, dropping off whatever X supply it is, are you going to require they wear masks? Well, they're supposed to anyway if they're within 6 feet. Are you going to come up with a process where they could drop things outside the door and somebody could pick it up so it's a contactless delivery, I should say. You're going to want to think of that. And then another common question that I do get, if you want to just think ahead, is could you have customers sign a waiver? And the answer is legally you could. They don't have the workers' compensation piece that we're worried about. You need to decide what kind of message that sends to your customers and your guests. You want to decide how you're going to say that in the best way that you can for your culture. But legally, it's an option. I'm going to quickly go through the next couple of slides because you are all certainly capable of reading them. Obviously, you need to get your managers trained in screening. If that's the person doing it, they really are going to be your number one folks to ensure your safety protocols are being followed. So you need to train them on that and also designate. And you need to have those discussions with your employees as well, not just give them the piece of paper and expect them to follow it. The next question that might come up is your order of calling people back or who you're going to call in to reopen. The two pieces here that are legal gotchas that I'll just remind you of we certainly want to not be discriminatory in who it is that we're choosing to come back. For example, we're not going to hire back all of the women and not have any men come back. That would show that we were making a decision based on gender, which would be discriminatory. So just watch out for that. But otherwise, if anything's based on skill, education, what shifts people work, that's fine. But you also couldn't say, I'm going to only call people back who don't have children because I don't want to have to deal with any leave rights. That would also be violation of the law. If you say, I'm not going to call anybody back who's disabled, and that's the last bit of question and answer that you have with the employee, you're also going to run into trouble. I want to go back. I'm not going to click back a few slides, but one of the things that I had on the earlier slide is, what if an employee refuses? Well, we're going to get to the question, but I want to mention that piece about disability. Somebody who says they have a health condition that prevents them from complying with any of your safety and health guidelines is going to trigger a longer discussion by law with that employee. So just hang on to that a piece. It's one of my cues here.
Oh, Catherine, as folks are calling back employees and they're doing that legally and not discriminating based on the slide you just presented, if they have employees volunteer information like, I don't think I'm ready to come back yet. I've got a kid that I'm, working hard to homeschool now that we've got, that requirement. They volunteer that information. Can an employer decide kind of to pass over them and call the next person if they, their current situation at home not working is preferable for them?
Yeah, I'm going to give you the lawyer's answer. So one is, sometimes you don't want to know things, but sometimes employee volunteer, which was your hypothetical, right, Julia? The issue is that there could be risk to the employee if they turn down a job simply because they like being at home better and want to be at home with their kid, even though, for example, their kid's summer camp is open. They could very well end up in a situation where they're no longer going to qualify for unemployment. Now, keep in mind, the person or the group that decides unemployment benefits isn't the employer. We should never, ever promise unemployment. That's going to come from ESD. So you're going to find yourself in a situation where you're actually making a decision about whether somebody can or can't come back to work because they have this protected reason. If an employee says they're no longer interested in working for you and they're not accepting work, really you're better off not trying to help them get benefits, because I never want us to be doing something that might run afoul of that. So there's really no definitive answer to your question, Julia. It's something that I would have to know exactly what was said and what was the context. There may very well be a situation where you just kind of let it go and you're able to get away with it, but there's some inherent risks in that dialogue. Okay, so if an employee says, I don't feel safe coming to work, what's key here is, why are they saying that? And this is a situation where I do want you to ask the question, because we need to know the answer so we can figure out what rights they have. So for example, if the employee says, I'm 66, which you probably know if you looked at their payroll records, and I have an autoimmune disease, which you may not have ever known before, they are going to be somebody who qualifies as a high-risk worker under our governor's order. And if that happens, you have a duty to talk to them about feasible alternative work arrangements. And I've given you the link here to an article that I wrote about this that can also take you to the governor's order. And look, for restaurant workers, for example, hotel workers, unless perhaps they're office workers, back of the house workers at the hotel, telework isn't going to be an option, but that is something that you should be thinking about where it could be appropriate for the position. So this would be the example of somebody who's maybe been able to do their payroll checking and payroll duties and been able to cut checks, and you're going to have to allow them to work from home a bit longer. The employee, in fact, also has the right. So, Julia, this could go back to if the employee volunteers that they have an autoimmune disease. This is a situation where you would want to let them know they have the option of using any paid sick leave or paid time off or staying on unemployment until their doctor says, or until this level, this guidance from the governor is lifted. So that's why the why is important. Back to my comment I made earlier about disabilities, even if somebody says I have an autoimmune disease, that's also going to trigger your duty to have a discussion with the client about that. I mean, is it something where if you gave them a job in the back room where they didn't interact with anybody, that would meet their doctor's requirements? Or is it really a situation where they need to stay at home? Then we're on the flip side of this question. I don't feel safe to work because of a general anxiety about commuting and coming back to work. I actually don't mean to make light of this. Some folks really are afraid. They're afraid to interact with the public. The answer there is, legally speaking, you have the right to enforce your policies. My but's going to be, I want your safety policies to really be safety policies that the CDC or the states recommended. And I want to be sure that there's not something else going here, which is why I'm saying you should consult with a lawyer before you terminate. But generally, this means you can tell employees that no, if they want to come back to work, they have to wear a mask and they need to follow your safety protocols. And you have a job for them. And if they don't want it anymore, then you'll consider that they have resigned or not accepted employment. Exceptions to that, again, are going to be because of disabilities particularly, or because they have leave rights, which we're going to get to here. I already talked a little bit about somebody who says, I don't want to wear a mask. I'm going to reiterate that the question to ask is why. Do they have a medical disability? In which case you are entitled to confirming information from their medical provider about their inability to wear a mask. I would say that 95% of the time when my colleagues and I get this question nationally, the alternative is to give somebody a face shield because the employees probably tried to say they're claustrophobic. There are alternatives. Again, maybe you've got a corner of your kitchen where somebody can wash dishes and they're not going to be within 6 feet of anybody. And again, they don't have to wear a mask. But things like, I don't want to, it smears my lipstick, I have acne, what's the other one I've heard? I just think it's itchy. Things like that are not legitimate excuses. So if somebody says, though, I can't wear it because of X, and it's something that might be a disability, you're going to ask them for information from their medical provider, confirming the reason that they are not wearing a mask, and to help out with some alternatives. All right, leave. Let's all take a deep breath before we get into this mess of entangled web of leaves. That's what I call it when I present just on this. The first question is, again, to ask why the employee wants to take the leave. And the reason is the reason for the time away is going to help us figure out what leave rights the employee may have. So we have Washington's paid sick leave law. We have Seattle's paid sick leave law. There's CTAC's paid sick leave law for any hospitality employers in CTAC. Those are rights that already exist that have been expanded in some way to cover, or they already covered some COVID-related issues. We'll talk about that in a second. We have our paid family medical leave from the state that started this January. Then we have these two new paid federal leaves under the Families First Coronavirus Response Act. One's a paid sick leave. One is an expanded FMLA. Then we have our usual FMLA. And then we have our usual leave can be a reasonable accommodation under the Americans with Disabilities Act. So the why is very important here. And even I these days need to ask that question of my client and pull up some notes so we can walk through all their leave rights, because the federal ones have really complicated the situation. So let's talk about some specifics for the Families First Coronavirus Response Act. I'm going to zoom through these because I'm going to assume everybody's got a general understanding at this point, and you just might have some questions for me. But the first one to point out is, before you panic about this, you want to be sure that you are a covered employer. So both of these laws only apply if you have fewer than 500 employees. Now, if you're a franchise, it's going to be measured just by your franchise. If you are an affiliated hotel, though, for example, with a chain of hotels with a common business owner, you may very well have more than 500 employees, and hopefully you've gone through that analysis with your legal counsel. On the other end of the spectrum is there is an exception if you have fewer than 50 employees. So if your total head count is 50 or fewer, and it is the time that you are open, it's the time that people want the leave. I did have a client ask me if they should only hire back 49 people. And we talked about what that would mean for this, but technically it's under 50. Then you don't have to apply these leaves if you have a member certify, a member or an owner of the company certify that it's going to be a hardship for your business and some other things. But basically it's that you have a limited availability for workforce. You won't be sufficiently staffed if you have to let somebody out go on leave, and really paying for this, even though you're going to get the tax credit, it's going to be a hardship. So the first thing is, make sure you need to worry about this. The next thing is, you are going to try to determine if
Catherine, could you reiterate, if they had 500 employees before the virus, and now they have fewer than 500 because they've laid off employees, are they a covered employer?
Yes, they are. So it's the time that you're taking the leave. So I just had a client who was part of a national conglomerate, and the conglomerate split up because of bankruptcy. And now my client's just a solo Washington business, and they suddenly now are a covered employer under this law.
Great, thank you.
And there's some details there that probably you want to consult with counsel about when the leave is going to become available. It gets a little complex, but yeah, it's the time of taking the leave is when you measure. Look, you need to figure out if your employees are eligible. There's 6 reasons for the emergency paid sick leave. That's going to be the 2 weeks worth of paid sick leave. And then there is only a single reason for the expanded FMLA, and that's child care. And really it's son or daughter. And that's it. It's up to 12 weeks of paid leave for that single reason. The first 10 days aren't paid. We're going to talk about that in a second. One of the things that I suggest you do is just get a compliant leave request form done. It's going to help you track whether the reason the employee is asking for the leave qualifies for either of these bundles. It's also going to give you a document you are likely to need when you go to get the tax credit. Here's what I was hinting to. This is the amount of leave. Remember, for paid sick leave, it's 80 hours only if you're full-time. If you worked part-time, it's going to be based on a 6-month look back. And keep in mind, too, I should have said, if you were closed, you didn't need to offer any of these leaves. They're becoming back to being important, though, as if you're reopening. And both of these are going to be available to the end of 2020. They expire on 2031. The regular rate of pay is what you pay for both of these, but the amount that you pay is limited by law. You can read this here. But it depends on the reason. Basically, you get more money if you're caring for yourself, but if you're caring for other people, you're only going to get 2/3. And then it's capped in the aggregate. And why the amounts are important is because you won't get a tax credit if you pay anything above this. I already suggested that to track compliance, you have a leave request form and you have a leave approval form. Generally, we have, if folks are familiar with the FMLA, a leave approval form. But I think you need to have one for the special childcare reason because it's a new thing and we don't know what you're going to need for the tax credit. Again, this is the details that you would have on the form. One of the things I wanted to just let you know is that, yeah, the employees have to give you this information and you need to maintain this information under current regulations in order to get your tax credit. Now, this is one of the places where I say, but, which is that we could see additional regulations from the IRS that's going to change this. Same with FMLA, you all can read that yourself. I'm going to try to zoom us ahead to some other topics here. But the consequences of getting it wrong, if you give somebody extra leave, that's really nice that you did that, but you're not going to get the tax credit. On the other end of the spectrum is if the employee was eligible and you failed to offer it, you're going to get a claim through the Department of Labor or a lawsuit. And in Washington, that's likely to be a wage claim. So it wouldn't be just the paid leave that you owe, it'd be doubled that amount. You could get a wrongful termination claim. Anyway, quickly, you can see that it's going to get you into trouble. I want to talk briefly about the state and city. Let's just zoom through what changed. Remember, Washington paid sick leave and Seattle's paid sick leave were always sick and safe leave. We just didn't worry about it usually because we saw this catch-all if the child's school or place of business has been closed by an order of a public official. But now it's mattered. So if those of you who are open probably already had to deal with this, this could be something that now you need to worry about going forward, especially if somebody becomes ill. The city of Seattle expanded their reasons. It's not just if a son or daughter school or place of care closes, it's any family members, but that's a Seattle only thing. The pitfalls I see here are forgetting that a high-risk worker has the right to use paid sick leave, PTO, or unemployment. I've given you a link here to the FAQ from the State Department of Labor, and I've cut and pasted it. But this is a good example of information that you'll find out, and it's probably a great place to visit if you're not sure you need to get somebody the leave. And don't forget about Washington's Family Care Act. I think everybody forgets about it. This is a law that says you also could use like your paid vacation if you need time away to care for a sick family member. This would be caring for somebody who has COVID, not a child care reason. It's a little bit different. And then Washington's paid family medical leave really isn't handling the day-to-day issues of folks having to deal with COVID. It's really for the situation where somebody becomes ill and needs longer than that 2 weeks that the federal government is requiring you to provide now. Folks are often out ill for a far longer period and they might qualify for Washington PFML. So you're going to want to remind them of that available law and encourage them to apply. Again, the state decides, not you. And beyond that, I'm not going to go into the details here. I just don't want you to forget about it. All right, the biggest pitfall is you forget to offer leave. So you forget to ask that why question and go through this checklist about what might be available. The other one is that you say, okay, I'll give you time off, but you only offer them the Families First Act because you're thinking about the tax credit. The employer really has the choice. They could use Washington paid sick leave first or instead of the Families First or both. And we need to be sure that we are letting employees have their choice. Other things is like, for example, if you think the employee could work from home, but they're saying they want time off to be with their kid, you should sure encourage that and let them know it's an option. But in the end, you can't force them to do that. They have the right to take the leave. And then there's just some things here about poor record keeping and poor policies that you can think about yourself. Okay, my last topic, I think we almost made it, is beware of wage and hour issues And the biggest ones here is I see adjustments being made to exempt employees' salaries. And the trick there is you are going to lose the overtime exemption if you change the salary every week, depending on how many hours the manager, usually is where you're claiming it, works. You can change salaries, but it has to still meet the minimum salary test, which is $7.84 an hour. And it cannot be dependent on hours of work. It has to be a set amount going forward. Now, you can have a side conversation with your manager that you're not expecting them to work as much as they normally did, but you can't fluctuate their time based on hours that they work. If you do, then you don't have the exemption anymore. I have a lot of clients who went ahead and had a lot of their workers just move to hourly. Especially, I've got one client where the only people who are there doing takeout are managers, and really they're not managing right now. So I'm not even sure we could claim the exemption. They're pretty much acting like cashiers and servers, and so it makes sense to try to not even claim the exemption. When you do that, though, you need to be sure you're keeping track of hours of work and getting meal and rest breaks and all of that good stuff. The next few slides are a number of places to go for resources. I'm not going to talk about all of them. I'm going to go back to the Q&As and see if I can answer some more questions for you in the last 10 minutes, because you certainly are welcome to click through. Some of these are from Fisher Phillips, some of them are from the association, and some of them are me giving you the landing pages where I think there's really great FAQs. All right, Julia, should I just dive in, or is there something you think I need to hit first?
I think you've answered a lot of questions, but there's just a few more remaining, and I think they're on the top.
Okay, well, great. Hollis asked if you need to log COVID screening questions for team members each shift, because there's an understanding that this is against HIPAA. So let's untangle that a little bit. HIPAA does not apply to any of you on the phone. HIPAA is a privacy medical law that has to do with hospitals and people who gather information. However, the Americans with Disabilities Act does apply to you all, and that does have some medical privacy rules. So what I said earlier was if you are maintaining any logs or any information about employee symptoms, you must keep those in a separate medical file, just like you would any leave requests, because that's what the ADA requires. You also need to ask those questions ahead of the shift, or sorry, at the beginning of the shift and separate from everybody, because we need to keep medical information. And then the last question is, well, how can I even log that? So you may recall from what I said earlier is that my logs not going to log the actual answers to everybody's questions. It's going to be a did you do them and were they all negative? It's basically a yes, no. You go through the questions. Do you have this? Do you have that? Do you have this? Do you have this symptom? And then you're going to keep a log that just says, you know, Catherine asked, basically I write Julia's name and the time she started and I do a yes, no. And that's as much as the log says. Now, I add some other things when I draft these about keeping the medical information private, explaining why you're doing it and how it fits with your safety protocols. But the log you keep is pretty much just a checklist that you ask the questions, the day that you did it, and who you screened. It's got pretty simple information. Looks like somebody asked again about this 500 employee thing. Sorry, Tim. Yeah, if you are now an employer with less than 500 employees, you likely are covered now by Families First, because it's your size at the time that the employee needed the leave. It's not the time that the employee, that the law was passed. That's a FAQ at the Department of Labor. You can Google Families First FAQs, Department of Labor, and get to it. But certainly your legal counsel could confirm that as well. It's a little bit of a gotcha, and I know can be hard for planning purposes.
Catherine, one thing I think we need to clarify again is regarding employees who've been exposed to COVID, not necessarily diagnosed, but they've been exposed. They had another coworker who was positive. Are those employees required to isolate? I think there's still a little confusion around that.
Yeah, they are required to isolate and not come into work. And so it's either going to be that they isolate for the set periods of time that the CDC has put forth if they don't go see a doctor, or it's going to be if they do go see a doctor, the rules are that they have to have no fever, no respiratory symptoms, and 2 negative tests.
Oh, 2 negative tests. That's helpful. Can we require that employees go to the doctor so they can come back to work faster if they're not sick?
You think you would be able to do that because it kind of makes sense, huh? Sorry, that's not the real answer. The real answer is you actually can't make them, because the assumption right now is that healthcare providers may be overloaded and you may not be able to get in to get a test. Now, you and I know that's one of the reasons that the governor is trying to get more testing and testing kits available so employees don't have that problem. So my answer is I would strongly encourage the employee to go get a test.
Great, thanks. And I just don't think it's possible to spend enough time covering masks. So going back to the mask question.
Yeah.
So if an employee says, I can't wear a mask because it's too hot in the kitchen and I don't like that, or I feel like I'm going to get heat stroke, or I don't want to wear a mask, it's uncomfortable and it's too hot for me, but they don't have a medical reason. What do we do in that situation?
Well, the governor's guidance is pretty clear. In fact, the mask requirements is in bold in the middle of the guidance. And it says that unless employees are working alone, and they have to wear one if they're going to be within 6 feet. So you have to get creative about an alternative. I mean, that's why I suggested a face shield might be something that is better. But it is just a requirement right now. And I sure don't want anybody to be the test case for a health inspector to come in and find out that folks in the kitchen are not wearing masks. In fact, I don't want one of your customers to find that out either.
Great. And we have been told by Labor and Industries that a face shield is not an alternative to a cloth face mask.
Oh, really?
Yeah. So for our folks on the line, it's a cloth face mask is the requirement. Now, if they do have a disability, they've got maybe, I don't know, I think I've heard one of our members say they had an employee who has a lung or asthma issue that is impeded by wearing a mask. And so they can't wear a mask on the job and therefore can't do their job safely as required. Are they now entitled to the leave, the different leave options that you've gone over?
Interesting. So we're saying that the reason that they can't come to work is because they have a disability that says they can't wear the mask.
Well, I think in some situations that's the claim that the employee has made, that I've got a health condition, I can't wear a mask.
Yeah, well, it's not one of the reasons under emergency paid sick leave here. I went ahead and went to that slide. See those 6 reasons? I can't come to work because I can't wear a mask is not covered. I do know that the ESD at least has hinted that maybe you would still qualify for unemployment. Perhaps we would have a reason to determine that that employee was a high-risk employee under that governor's order. But that's definitely something I don't think I can give a definitive answer to. I also find it, I think that I don't want to say this and get everybody excited, but I would frankly fight with Labor and Industries about a face shield not being acceptable if somebody's got a disability and can't wear the mask. But that's a fight for another day. And for somebody who probably wants to take that on, we have to follow the general guidelines that they're giving us that Julia just put out.
Great. Well, I don't see any more questions in the chat. I'm just going to look through it one more time.
Yeah, I also know we could talk about leave for the next several hours as well, in addition to masks. The rule of thumb I just want to give you is this is something where the FAQs are really going to help you. The Department of Labor, I mean, they're up to 90 some now, but the good thing about there being 90 some is your question might very well be in those FAQs. All of our agencies on a state level have a COVID landing page with questions. And so there often is a resource available to you where we may not have a regulation on it, but at least we have the agency giving us guidance. And I will say from my point of view, I found more answers than I found questions when I go through that exercise for someone. So hang in there. There is help to be had. There's just a lot of information to wade through.
Great. Thank you, Kat. There's lots of compliments in the chat for you. So thank you for your time today. One thing I know that a number of our members have indicated as a difficulty getting restarted and up and running again is the issue of unemployment insurance benefits being more than what employees would make working. And on that topic, I wanted to give everyone a primer that we're going to have a program, the shared work program that is under Employment Security Department. It's a form of UI benefit. We're going to have a webinar next week, trying to lock down the date here, but go over how to bring employees back at a part-time level where they can still receive benefits from the Employment Security Department, as well as maintain the federal $600 weekly benefit. So that will be coming next week, and look forward to that as well. Catherine, anything else you want to leave the group with?
No, but please, reach out to your area coordinator. I've given you my contact information. If I can answer, a general question quickly, I do. I'm actually one of the people you might have talked to if you've ever used the advisory network. And the association has tons of great materials too. So everybody's here to help. I want folks to get this right. I want you to reopen and welcome guests and, be worried about your business as opposed to this other stuff. And I think there's a way through all of that. So I'm thinking of all of you.
Great. Thank you. And that concludes our presentation. Everyone have an enjoyable rest of your day, and hopefully we'll see you next week. Thank you.